Hello everyone and welcome to week 6. We're halfway through the course, which is pretty scary. So this week we're looking at the topic of being a lawyer and being ethical, and as promised earlier, we are taking a little bit of a break from the heavy technical material we covered in the first part of the unit and moving more into the interesting social, contextual, practical part of understanding the law and lawyering. So we did front end the course with a lot of that technical stuff on using legal information, accessing legal information, legal research, precedent and statutes, and that was to get you up to speed very, very quickly, as quick as we could. And now we've got a little bit of a breather in terms of being able to discuss the wider context. So this material is just as important, of course, but it is not as intensive or as new, and most of the themes in here are things that I'm sure you'll be familiar with in terms of pop culture, even if you're not absolutely certain about the technical origin or authoritative sources of some of these concepts. Alright, so we start with the general concept of advocacy as the role of lawyering. That is, it's a helping profession and it's helping stand between people and some particular conflict. So usually it involves the law, the state, regulation, all those related things. But a lawyer is an advocate who stands up for someone, and a lawyer knows the system and helps that person navigate the system. Now, the role of the lawyer as an advocate does potentially spin off in several different directions, and there are reasons why there are ethical boundaries around some of this. Some of it's unavoidable, but sometimes you may find yourself having to help people with things like financial literacy or business organisation or personal finances. And in fact, a lot of the community legal centres do as much, if not more, work in financial literacy for people who've gotten themselves into trouble with debts as they do with legal problems. You'll also find a role as a conflict manager in helping people manage and negotiate conflicts in their lives, and being able to find solutions that are short of taking someone to court and suing them. Being able to work with, particularly with family, business associates and so on. And there's also an element of psychology or therapy in being able to understand people's needs and being able to help their personal needs. Now, all of those things are things that lawyers are not qualified or insured to deal with, and that's one reason why, it's a strong reason why there are ethical boundaries around what lawyers do. A well-intentioned lawyer could do a lot of damage to someone in giving them advice in areas that are outside their expertise. And one of my family law teachers actually gave me some fairly brutal advice early on that does make sense, was that if a client starts crying, give them a box of tissues and send them out to the waiting room and tell them you're being charged X number of dollars a minute to sit here and cry. My job isn't to counsel you, and in fact, if I did, it would have been an extremely expensive source of counselling. So I'll stop the clock, go out into the waiting room, have a good cry, get it out of your system and come back. And I know some people find that shocking or appalling, that and it sounds quite callous. But when you get the point that the clock is running on a client's hours, saying there, take as long as you like, cry as long as you like, it's a very expensive cry. So the ethical position is to really point out to that person what it's costing them and what their alternative options are. So yeah, one of those reasons, one of those things that's the most difficult, I think, to maintain is that sense of a lot of people's problems are not going to be purely legal. They're going to be tied interconnected with a lot of other things. And you go into a danger zone when you take it onto yourself to represent yourself as an expert in those things. And lawyers will often keep a and when we talk about people working in the profession, we'll come to that in a moment, do keep a set of cards and resources for people to recommend and say, here's a good counsellor, they're really good to talk to, here's a good financial planner, accountant, they're good to talk to about those areas. And the next section, which I guess I just flagged, was what is it that lawyers actually do? And this whole area is very important, not just for people who are in the law degree who are looking to work in the law, but it's also very important for people in other professions, for criminologists, to understand what it is lawyers do, and what their legal and ethical obligations are, because I think that's very important in those interagency collaborations that become very important. So a lot of our focus on what lawyers do really focuses on the idea of legal practice. And this is a little bit misleading because this is actually the minority of what law graduates do. So we think about lawyers in the law office, either the wealthy commercial firm with the corner office and so on. Many of us may dream of that as law students. Very, very few people ever get those jobs. Or, the helpful local suburban solicitor. Now, both of these roles only represent a minority of law graduates, and they are swiftly becoming extinct, particularly the local suburban solicitor. I was passing through, I think it was Ferntree Gully. It's Ferntree Gully. And I saw the local solicitor there had gone and had been replaced by a vinyl record store, which is kind of amazing that vinyl is back in a way that it's more profitable and viable than being a solicitor. So the reason for this is just the stagnation in the economy and the fact that legal services are really outside of the reach of most people now. So a lot of the discussion on the future of the profession seems to indicate that the way it will go is that there will still be the need for these bespoke practices, these big firms, but their business will pretty much all be big businesses and the wealthy. And where there'll be a gap is for ordinary people. And it's not just a case of, it used to be once that it was an issue of poverty, and pro bono work would cover the work of the work for the poor. But middle class people can't afford lawyers anyway. So Susskind, who's a person who's done a lot of work in this area, has theorised, and he's looked at changes in the UK, and he suggested that lawyers will go the way of Priceline, that you'll end up with these big sort of high street legal conglomerates. They may actually end up being located in banks and part of bank services, and you just are one of the rostered lawyers on, like the same way Priceline has a whole lot of pharmacists that are there, and they'll have cheap, low-cost solutions for the majority of legal problems. So all of this sounds kind of depressing for people who are aspiring to work in the law, that the traditional career path is drying up. And even within the big firms, they're offshoring everything that they can in terms of work to China and India, and they're also looking at automation as a way of reducing their costs. So what does that mean for people who are graduating from law? Well, the graduate surveys suggest that the rates from law qualifications are still, the employment rates are high. Salaries have never been great in law. Again, there's been this misinformation and glamour around, the legal, particularly American glamorous legal shows, whereas the reality of legal practice is probably closer to Better Call Saul than anything else. And one of the things that you don't necessarily know about big glamorous legal firms is the incredible amount of debt that American law graduates carry with them into practice, which requires, it's called the golden handcuffs. They have to be employed in big prestigious firms because their debt is so crushing. as graduates. So the reality is there are a lot of people with law degrees who work in other areas, and in areas where having someone who understands regulation, who understands the way in which a bit of psychology, a bit of how deals work, a bit of how to negotiate with people, all those related skills are very transferable to a lot of other areas. So, for instance, banking used to employ a lot of business graduates in their graduate programs. Now, I believe they're pretty much all law graduates, because of the decreasing esteem of business degrees, and the fact that there are plenty of law graduates to go into those programs. So those are reasonable mid-range kind of middle-class jobs that a lot of lawyers are going into, working in banking and finance. They pick up the numeracy bit along the way, but what they're really knowing is what is someone who can work with things like mortgages, and they're not writing mortgages; they're copying them from doc files, but they still want people who know how the system works if things go wrong. So in terms of, back to that question of what is it that lawyers do, it's an increasingly diverse field, and it's increasingly unpredictable going forward. However, we need to focus on what those core skills of being a lawyer is: understanding systems, being able to explain those systems to other people, being able to make arrangements and predict risk and make arrangements that appreciate that risk, being able to make deals, being able to understand the needs of different people in conflict. All those foundation skills are the things that are going to be more important in the future. Knowing about the tort of nuisance, possibly less so, if it is that relevant these days anyway, or if it's ever been all that relevant. So you get a bit of a, those of you who are law students, you get a bit of a misapprehension about legal practice from the law degree, because it's rooted in this very old-fashioned idea that every law graduate will go out and become a solicitor, and they'll do this and they'll do this. And honestly, that isn't the way it is. And it wasn't been since I graduated. I think I graduated about the time where the number of law graduates first grew larger than the number of jobs, and that was a long time ago. And people were wringing their hands and saying, "Oh, is this the end of law degrees? Why are these law schools producing all these excess law graduates who are not going to get jobs?" Well, they all got jobs. Maybe to the misery of the business graduates who lost those potential jobs, but lawyers certainly went out in different directions, and the discipline of being able to work with law, work with text, being able to do that serious close level analysis of what words mean and what they say, they're all really important skills. Alright, so I hope that didn't depress people too much. Obviously, if you've got your heart set on being the lawyer with the corner office, with the expensive lifestyle, you've got a lot of work ahead of you. And you've got to really start committing now at the start of your studies to make sure you're making connections, that all your results are top grade, that you're volunteering. Really, it has to be your life if that's the direction you're going, or you have to already have those connections. That's how many people get in that way, but you aren't in a position where you can just cruise. If that's the direction you want to go, you can't just cruise through your law degree, prioritize it lower than other things in your life, and expect that someone will come along with, the keys to the Ferrari in the corner office once you graduate. That's simply a fantasy. And the truth is, if you do have things in your life, you have family commitments, you have other priorities, you're not going to be able to make it in that path. And that's the brutal truth of it. But the good news out of all of this is that you can forge your own path, and there's lots of different options, and lots of different options that are probably better for you. You won't make as much money, but you're going to have a better life than people who are living for the law, and doing nothing but, spending 16 to 18 hours a day in the office doing law work, and then collapsing in an exhausted haze at the end of it. All right, so that's what lawyers do. The next section we talk about legal ethics. Important thing to look at, important to know the source of legal ethics, particularly the National Australian Solicitors Conduct Rules. So read that material. Important to know what the source is, have a bit of a read of those rules and see what sort of things are covered, see what sorts of things are not covered. If you're a law student, you'll come back to this, and there's be a specific subject that will explore conduct and misconduct in detail. The starting point, I guess, for me is always, as someone with a law degree, is what I call the rapist problem, which is when someone finds out in a social setting that you've got a law qualification, and they say, how can you defend rapists and child molesters and serial killers and all the rest, which of course happens every day in legal practice. But there is that sense of lawyers being terrible people because they defend these horrible people. How could you be a lawyer for Derek Chauvin? And I must admit, when I'm recording this, the jury has just gone out on the Chauvin trial, and that was a pretty tricky defence and not a very good one. But I don't know they had much to work with there. But at the end of the day, as people say, you're a lawyer, you work for horrible people, you must be a bad person. Now, the response to that is, we live in a society where everyone has the right to be presumed innocent until proven guilty by a court, by a jury of their peers. Therefore, it is not up to any one individual to judge if someone is guilty or not. If you lived in a society where one person could just decide someone's guilt, that would be a fascist authoritarian society, not one that I want to live in. So if I, as a lawyer, took it on myself to be the judge and jury in every potential client and say, no, I'm not going to represent you because you're accused of terrible things, then I would be acting as a fascist. I would be taking those roles onto myself. So there's that difference when we're looking at ethics between the duty you have as a lawyer to clients, duty to society, and duties to the law, all of which point to the fact that everyone, no matter whether they're guilty or not, and whether they get proven guilty or not at the end of the day, is entitled to a fair defence. Doesn't necessarily mean you should go out of your way and use trickery and underhanded methods to defend people, but you shouldn't do that with innocent people either. Basically, your role is to give the person that the defence that everyone deserves. It would be the same if a doctor came in and had a client that they didn't like and said, I'm not giving you any medicine, I'm not giving you any treatment because I don't like you. Now, the idea of professions is that the professionals do not make those choices, because otherwise, there'd be a lot of people who'd never get representation, who'd never get healthcare. A lot of people innocent people, including who everyone thinks is guilty. The media has decided someone's guilty, and at the end of the day, turns out they're not guilty. What's your role then if you decide on the basis of something you read in the newspaper or heard on Facebook that that person did not deserve the best possible defence available to them? So I think that's a starting point for ethics, and that's always the that division of your role not being the judgment role, your role being just to give that person a fair trial. Of course, that can lead to consequences. There's all sorts of well-being things associated with being tied up in those trials, and there's also well-being issues with all aspects of the law. And as I sort of flagged earlier, that idea of being, the lawyer who represents the scumbags of the earth. There's so few lawyers who end up in that sort of role or in that sort of position. It has been much more of a meal made of it in the media and in fiction than there is in actuality. So it doesn't really come up. But that is the sort of the high-end ethical argument that people always start with, and you always get. And the easiest thing to me has been that response is that I don't live in a fascist society. I don't want to live in a fascist society. Would you like to live in a fascist society? Would you like me to judge without any evidence or process what you're guilty of? And people generally don't find that comforting. They generally would not prefer for you to be able to judge them as they prefer to judge other people. Very crucial part of ethics to consider, and it's part of the focus reading this week, is ethics at law school. So criminology students, you can go to sleep for a little bit, but law students, your conduct in law school is extremely, extremely important. Depending on the jurisdiction, even the fact that you have been investigated for misconduct. Whether or not you're found to be culpable for it is something that you have to report when you go for admission, and is something that can lead to a decision to have admission refused, or if you fail to disclose it, have your admission revoked later on. So it's quite serious. Most of the cases involve people who are accused of cheating while at law school, or plagiarism, who don't disclose that when they go for admission, and they can basically lose their whole future and waste their time and energy by not disclosing that. And it's taken very seriously. You have to disclose everything, particularly things that relate to your honesty and conduct. And some of the people who've been tied up in this as graduates have been caught on things like a group assignment in a business subject. They're people who've done a combined degree. They did a group assignment in a business subject. They got pegged for plagiarism. The group got pegged for plagiarism. They didn't disclose this when they went for admission. In fact, they possibly didn't even remember it happening when they went for admission, and they lost their admission over it when another student who was a member of the same group went for admission and did disclose it, and then the admissions board went back through their records and said, "Hang on, this person's already been admitted, and they didn't mention this," and created all sorts of trouble. So yes, the moral of the story is stay out of trouble when you're a law student, and if you can't, make sure you disclose everything and hope for the best. Increasingly, jurisdictions are also asking deans of law schools to provide a letter. This happens in a couple of jurisdictions. I believe Victoria does. And other jurisdictions are looking at doing that, but they ask for a cover letter from your dean to say that you're a good student and so on. So that's beyond just not being a bad student, that you need to have a letter. Now, most deans are not going to be spending a lot of time going through their records and going, "Oh, who is this person? What do we know?" and whatever. They're probably going to just produce a whole lot of letters for everyone, unless someone has been a particular problem, in which case the deans will have a discretion to say, "I don't think this person is a fit person to be a lawyer." So again, even outside of formal misconduct, there are some jurisdictions in Australia where you have to be an exemplary student at all times and not be a troublemaker and not be up to things that are that are short of actual misconduct. So going into interesting times with that stuff, and of course the admission bodies can change their rules at any time, and they don't have a problem with being backdated. So they could change the rules, in 4 years' time, 3 years' time, before you graduate, to have a problem with something that you're doing now that is currently not a problem. If you know what I mean, They don't have any rule against retrospectivity, to use the technical terms, in their admission rules. So, for instance, when that issue of plagiarism on a business assignment went through, some people believed that the rules around academic honesty only related to law units, and that if you got tagged on a business unit, it wasn't a problem because the admission body would only look at law units. Well, the admission body changed the way they did things and started looking at those business units too. So yeah, there is a great deal of uncertainty around that. With their ability to make those changes, we presume they're not going to make too drastic a change going forward, but it is, if you're a law student, it's absolutely crucial you understand that process and you understand the risk, because you're paying a lot of money. Everyone's paying a lot of money. Criminology students are now paying much more money than they used to for their qualifications. But if you're on have a qualification that requires admission, then you've got to be very, very careful. All right, and yeah, part of that is not being able to say, "Nobody told me." So this is the point at which we do tell you, and we will tell you again through your degree. Okay, touching base back with everyone. There's another couple of sections in the book that we touch on a couple of other issues involving the practice of law. We talk about them just a bit generally here. They're things we're going to come back to in other units and dig into in more depth. The first is the idea of legal communication and the importance of law being a communicative profession. And that has elements of spoken communication, written communication, and so on. And the big takeaway here is that legalese is not something you do as a lawyer. As much as people do it, and as much as there's this idea that from media that legal documents were written in the party of the first part, that hereinafter, henceforth, will be referred to under the Schedule 2 reference, blah, 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 legalese. Good lawyering is about clear communication. You may not think that when you look at some of the legislation that we ask you to study, but one of the core parts of the legal experience, the legal profession and professionality, is being a good and clear communicator. So have a look at that material. And the final part, which is a very open-ended, is the idea of lawyering and good. And what is it to do good as a lawyer? Is to go back to the rapist analogy, providing a successful defence for someone who, probably you think is guilty, but you provide a successful defence because the police investigation was shoddy, and you're able to poke holes in how bad the investigation was. Are you doing good there? Or you are doing good in that you are keeping the police accountable, and you are and that affects everyone, and you are providing a fair defence for everyone regardless of whatever. But do you feel as though in a sort of an Aristotelian sense you are doing good, you are living a good life? And that's an open-ended question. That's something we're going to discuss further going forward, and that has significant impacts on well-being. And I don't think it's generally the rapist dilemma that impacts people's well-being. It's working for big banks and big money, and spending day after day after day making more money for big money. What does that do to you? Are you doing good there? And that's why a lot of lawyers do pro bono work and work in community legal centres, is because they need that sense of actually dealing with real people and helping real people with problems, as lawyering as a field becomes more and more aligned with big business and big money. And that's where I think those stresses lie. So lots of stuff to get your teeth into this week. I hope you'll find those materials very interesting. And we'll have a bit, and it's a bit of a, the last few weeks we're going to start looking at some of those. The second half, I'm talking like the thing's almost over, but the second half we spend a lot more time looking more broadly at those law and context issues. Now we've covered the heavy hardcore stuff in the first part of the semester. Okay, I got to the end of the recording and I realised that I had not yet discussed the check-in from last week, so here we go. First question was what people found most difficult about the module, and not surprisingly, the questions were a lot of the feedback was around the doctrine of precedent, and it is one of the most complicated things you'll be studying this term, and we don't say that up front because you don't want to say to people, oh, by the way, this thing we're going to learn this week is really, really hard, but it is probably the most complicated thing that you'll be studying. So don't feel bad if you found it difficult or challenging, and like a lot of things, a lot of it is just practice. It's just getting into it and working with it and seeing looking at cases, looking at the structure, looking at the way in which the judgments are written, discussing what, and this is more of an issue, I guess, too, for the law students and the criminology students, but in the law students, you'll be doing this in your other units. So make sure when there's shorthand where someone says, oh, it was a 3-2 decision and this was the outcome, that you look a bit closer and you go, okay, how did that get structured? How was that split up? A few people thought the quiz was quite difficult this week, so I'll pass that on to the designer of the quiz, and we'll have a look and see whether the quiz is difficult as such, or it's just because the content material is difficult, which is what I suspect it is. But yes, doctrine of precedent is the most common one. We had a few people talk about stare decisis, and stare decisis is literally just let the decision stand, and that is a situation where a court is considering its own previous decision, and the tendency is there, unless you see a big problem, just go with what the previous decision is. So stare decisis sounds more complex than it is because it's Latin, but really it's like if you've got the same court's made a previous decision, all things being equal, go with that, follow that decision, don't make a different one, unless you've got a really good reason. Not an ironclad rule by any means. It's more of a tendency or an approach. Radio. Someone said they had difficulty with what cases are distinguishable from others because they're not 100% sure what classes as a material difference. And yeah, that is the trick, and there is no easy answer to that, and that's all about good advocacy and making a good argument about saying, in this case, the fact it's a red Toyota makes it a completely different case than the one that was a blue Falcon. And at the end of the day, it's semantics, but it's about making a good argument. It's a thing you get a feel for as you go on. How did people go with the forum task? Did they agree? A lot of people said they were pleased to see that everyone was on the same page. So that's really good to hear. That was the biggest trend in that piece of feedback, was that a lot of people found that they were thinking in the same way as their peers, and that's always a good thing, I think, to find out. Not that you should always be conformist, but to realise that you're on the same page as everyone else. What did people find most interesting this week? Precedent, to precedent. And jurisdiction, how confusing the whole precedent thing can be interpreted. So we've got a running theme through these questions, and it's true. Getting your head around precedent is one of the hardest things about understanding the law. And as I mentioned, I think in my group last week, I might have mentioned that or maybe it was the videos last week, if you come from a very structured, rule-oriented legal system, such as China, that approaches things quite differently and doesn't have all the wiggle room around precedent, this is completely confusing. That if you think, these are the rules except the exceptions and the exceptions to the exceptions to the exceptions, people throw their hands up and say, how is this a legal system? How can you possibly run your system when no one knows what the answer to any of these questions are? And of course, we growing up with this system go, but that's just the way it works, and that's what's fair. So there's different cultures have different approaches, but if you approached legal study thinking that law is all about, the rules are set and we just apply the rules, then you'll have been, I think, very challenged by this material. All right, what would you like to have explained further? Someone's asked where tribunals fit into the court structure. Tribunals are not judicial bodies, they're administrative bodies, so they're basically bureaucratic in nature. And while we're on it, commissions of inquiry are the same. So they often look like courts and they set themselves up by courts, but they're not actually courts. And there's no structural difference between a tribunal that looks like a court that has someone who sits up the front and people who give evidence, and a tribunal where people just send in written requests and someone processes those requests. So tribunals are not part of the judicial structure, they're part of the administrative structure, just like any other sort of bureaucrats. Often tribunals get a little bit above themselves because they get to sit in a big chair. Tribunal members feel like they're very important, but ultimately they're a different sort of thing to a court. Other questions that are generally around precedent. Anything else there that I need to... brief explanation of mind mapping. Mind mapping is a really useful tool to visualize and think through problems. Rather than myself explaining it, I'd say Google mind mapping and have a look at some of the particularly things that are more credible, introductions to mind mapping, rather than things that are just selling a product. But mind mapping is just a way of getting all these complex ideas out on paper. And for things like understanding precedent, it's really, really helpful for most people. Most people don't sort of think textually, and they can't keep all of a whole series of judgments in their head, and being able to break it down into boxes and tables and arrows and all those sorts of things is very important. Stare decisis came up again. Again, don't get daunted by the Latin. Alright. And again, the idea of distinguishing cases and things, again, is an issue. So my, solution, my overall closing the loop on that feedback is, don't be daunted by the difficulty of the topic this week. Didn't want to flag it as difficult going in because we didn't want to set your expectations. But if you've got through it with a rough idea of what's going on, congratulations. And for the law students, you're going to have a lot more practice of this. For criminology students, it's just really useful that you understand the way in which law operates and what lawyers do inside the courts. But you're not going to need a practical applied knowledge of this practice once you leave this introductory subject. All right. Thank you for giving feedback on the check-in, and we'll check in again next week.